grabbing lunches quickly, and feel free to eat and all that good stuff and take breaks if you need to. But I was in just a teeny bit of a hurry today because I'm excited I get to go to Judge Stephen Powers' investiture this afternoon. Some of you know Steve, and he's getting sworn into the Oregon Court of Appeals. So I thank you. People made adjustments so that I could get down there and also have a chance to greet you and speak to you. But if you have to leave really soon, you can always just read the article in today's U.S. News and World Report entitled "State Attorneys General Lead the Charge Against President Donald Trump." It's actually a really good article. Yeah, no, it's excellent, and so I urge you to read it. I even have a few copies. I know people don't copy things anymore, but I still like to. So thank you, Mick, for the introduction. Thank you to Shelby Smith for inviting me, and for all of those of you who are active, especially the law students in the American Constitution Society. That's wonderful that you have chapters in your schools, and it's obviously something that we really need right now. So thanks for inviting me to join you to meet and consider the new role of federalism and its potential to support progressive legal causes and values. A few months ago, it became clear we at the Oregon Department of Justice were having trouble keeping track of all the actions of the new administration in Washington, D.C. that we felt we needed to review due to their potential harm to Oregonians. So we created what I dubbed our Federalism Committee. But I have to admit that name felt so strange that I didn't even want to include its name on the office calendar. So then when I got your invitation to speak and was told the topic, I suggested maybe we change the name of our committee to the Progressive Federalism Committee. All our work is still the same, but the addition of the word progressive reminds us that what Democratic state attorneys general are doing is not just taking a page from the Republican AG's Obama-era playbook. Instead, we are onto something that more aptly describes our legal work, fighting rollbacks of federal civil rights, environmental and consumer regulations. So I really appreciate your invitation to engage in this conversation and to tee it up for the panel of experts that follows, which unfortunately I will miss, but I know it's going to be wonderful. At heart, whatever we choose to call what we are doing conceptually, I think we in this room would agree that in doing so, we all share the goal to have the law serve as a force to improve the lives of all people, which I believe is sort of the theme line of ACS, and it's certainly what I think about every day. On my watch at the Oregon Department of Justice, we've set out to achieve two major goals. First, to provide state government with the gold standard of legal service, and two, to do everything in our power to look out for the most vulnerable among us. We think of ourselves first and foremost as public lawyers, and we try our darndest to uphold the finer aspects of that tradition. The arrival of the Trump administration has, however, given our work an added dimension and greater meaning. That's because this administration threatens the civil rights and well-being of more Oregonians than any, certainly in my lifetime. The top attorneys in my office have been thinking about that very issue virtually every day since January 20th, 2017. But first, some context. Yes, like you, we check Twitter and various news feeds early each morning to see what new executive order or other federal action has been taken. But although I am admittedly now a politician, it is not politics that drive our curiosity. It is the law. These federal actions chip away at our individual freedoms, at our collective rights as Oregonians, as voters, as women, and indeed as Americans. As Oregonians who were promised certain inalienable rights and who believe in the integrity of our Constitution and the guarantee of the rule of law. Although state attorneys general have always worked together, particularly in consumer protection, we are more and more looking for ways we can partner with and support other states as they engage in these same battles. Since late January, no less than 22 of us, and that happens to be the number of Democratic attorneys general, have been meeting as elected AGs on a weekly basis to share and find ways to work together to address the new administration's assault on our freedoms. We have a Tuesday morning telephone call, and we also meet together in person every few months. It's hard to believe, but on behalf of Oregon, we have sued the federal administration 7 times since January. We tackled the first travel ban, joining the state of Washington's lawsuit as a plaintiff and supporting Hawaii's successful challenge to the ban through an amicus brief. These actions forced the administration to seriously revise the ban at least 3 times. And of course, this case is ongoing. From the outset, we believed this executive order was a thinly veiled attempt at religious discrimination, and we wanted to make it clear that the constitutional limits and protections of the First Amendment apply to the president as well as everyone else. Without state attorneys general poised and ready to act on this from the very outset, this executive order could have and probably would have taken full effect and harmed many people's lives in the process. We actually sued twice on the travel ban. First, we challenged the original executive order, and then the revised one, which the president complained was watered down, both on constitutional grounds. We made multiple claims. We alleged violations of both the Fifth Amendment Equal Protection Clause and the First Amendment Establishment Clause, based upon a clear and unconstitutional preference for one religion over another, over others. We also alleged a violation of Fifth Amendment due process and claimed that the order violates the Immigration and Nationality Act. And we alleged violations of the Religious Freedom Restoration Act and both substantive and procedural violations of the APA. So if you're taking the bar exam, constitutional law, there's some good issue spotting for you. And of course, we alleged a violation of the 10th Amendment guarantees of states' rights, in particular that the federal government was commandeering the state's authority by requiring states to engage in discrimination and other prohibited acts. Recently, we sued in support of our around 15,000 Oregon Dreamers. The number fluctuates from around 11 up to 21, depending on whether you're talking about those who have already been approved, those who are in the process, et cetera. So I'm going to use the number 15,000. We challenged the repeal, the rescission of DACA. Lawyers in my office gathered declarations and prepared a statement of interest on behalf of the state of Oregon as a plaintiff in the lawsuit against the current federal administration in support of DACA recipients. The case is now in the discovery stage. However, the federal government has objected to our taking the depositions of federal agents, filing both a motion to stay and a writ of mandamus, and I understand as recently as this morning, they're now filing a motion to dismiss. Is that right, Kamala? Did I have that right? Okay. So we have to keep up literally moment to moment. In essence, they're claiming the courts have no authority to review the immigration decisions of Attorney General Jeff Sessions because they fall within his prosecutorial discretion. Our expedited briefing is due Tuesday, so stay tuned on that one. In deciding to join this lawsuit, we considered how the federal actions harmed Oregon in particular. We felt that bringing the lawsuit was necessary to protect the interests of our state, which is enriched by the DACA program and these exceptional young people. I happened to be with a number of our DACA recipients just last night at an event celebrating CAUSA, which is a very important immigrant rights organization, and a number of them were there. I actually posted a picture to Facebook this morning of me with the 2 co-chairs of the DACA coalition, Leo and Zaira. And Fatima was one of the recipients of the awards last night, and you got to just hear her speak, meet her. She's amazing. And they're just examples of these 15,000 in Oregon. We're talking about many, many more thousands, of course, around the country. So more than this number in Oregon have come forward, passed background checks, received permission to live, work, and go to school legally in Oregon. And if we end this program, we lose thousands of highly educated, motivated, tax-paying, hey, even the Republicans like that one, right? Tax-paying, contributing members of our society, part of the fabric of our communities. They're our friends, they're our coworkers, their children, their parents, their teachers, their counselors. They even serve our country. And their absence would just be a tremendous loss. Along those lines, we asked ICE, this is a great one, we asked ICE for records about detainers and immigration actions. And guess what? They didn't respond. To hold them accountable to the Freedom of Information Act, like everyone else, especially on this very important subject of information regarding their expansive ICE enforcement, we filed a declaratory action to require them to turn over their records. And that was just about a week ago. So most of what I'm talking about is pending. I'm afraid that I can't give you the end of the story yet for most of these, but stay tuned on all, and it's all public information for the most part, what's going on. Last week, we took on healthcare, suing along with 17 other states because of Trump's rollbacks of ACA subsidies, the CSRs, cost-saving reductions, that hurt middle-class Oregonians. In that complaint, we allege that the administration's actions violate the APA in that they are arbitrary and capricious, are not in accordance with law, and exceed the agency's authority. If you've taken administrative law, you know what I'm talking about, right? Okay. We also allege the actions violate the Take Care Clause of the Constitution. Have any of you studied that yet? You should. I didn't know any. Honestly, I've just learned so much. I thought I knew a lot about the Constitution, but hadn't even really heard of some of the important clauses. Earlier this week, we sought a temporary restraining order in this case, the ACA case, which was denied by the district court, in part due to the efforts that states have made to mitigate the impact of the president's actions. So while this ruling against the states has received a lot of press, rest assured that this fight is far from over, and we believe our substantive claims are strong. On the environmental front, we filed a lawsuit in support of the Clean Power Plan, defending the authority of the Obama-era EPA to create, remember that EPA? To create the plan. And now that the administration has issued a rule repealing the plan, we're filing formal objections to the new rule. You know, I got to know, you get to know all your colleagues at your various national association meetings. I got to know Scott Pruitt a little bit. I just had no idea, really, what he was up to while he was still AG and as EPA director. It's pretty horrifying. So we also sued opposing the delay of clean air accident rules in support of a rule on greenhouse gas emissions and opposing delay of a rule on new energy efficiency standards. Thanks to litigation during the Bush era, we already have judicial opinions that grant authority and standing to states to require the federal government to control greenhouse gas pollution under the Clean Air Act. And now, as part of the lawsuit to defend the Clean Power Plan, which is pending before the DC Circuit, we may also find ourselves fighting against the EPA's authority to issue a repeal of its rules, essentially dismantling the Clean Power Plan before it can even take effect. Several state governors and AGs, including us, have begun to form a coalition committed to maintaining laws and enforcing environmental protection locally and continuing to aggressively demand action nationally. We also have a team poised and ready to act to protect the Cascade-Siskiyou National Monument in Southern Oregon. Are any of you from Southern Oregon, possibly? Well, even if you're not from there, you've visited, and it's an absolutely incredibly beautiful area, in particular, this monument. Interior Secretary Zinke's recommendations to the president to rescind the national monument designation, either in full or in part, have us moving fast to establish concrete and real harm to Oregon caused by this possible action. In case you're wondering what that might be, for those of you not familiar with it, one of the primary scientific reasons supporting Obama's decision to expand the monument last year was the undeniable effects of global warming on the fragile and biodiverse ecosystem, which has begun moving up the mountains in order to adjust to the warming climate at lower elevations. But if you really want to know what we've done in the environmental arena since January, take a look at the article from the New York Times a few weeks ago setting forth the 52 environmental rules that are on the way out under Trump. We decided as kind of an interesting exercise to see how many of those we had formally weighed in on by letter or by whatever mechanism. My office has pushed back on no fewer than 20 of those 52 rule rollbacks, and that's because those 20 are the ones that most dramatically affect Oregon. Certainly, they probably all do in some way, but we have to be a little bit careful about doing everything. So we try to pick and choose what is most affecting, most harming Oregonians and our environment. You may have heard that some of my AG colleagues filed a lawsuit against the administration under the little-known Emoluments Clause. There's another one, okay, which prohibits the president from accepting gifts from foreign governments. How many of you, except the constitutional scholars in the room, knew what the Emoluments Clause was before this year? Come on, be honest. Tell the truth. I really didn't. Another significant legal action we've taken in Oregon is the amicus brief in the redistricting case, Gill v. Whitford. The outcome of this case is, of course, critical to our nation's electoral system's future. My Solicitor General, Ben Gutman, took the lead in authoring this multi-state amicus brief in support of a more fair system of redistricting and specifically against extreme partisan gerrymandering. The case is currently before the U.S. Supreme Court. This is the case out of Wisconsin, by the way. So we are on the side with the Wisconsin voters and Common Cause. It's currently before the U.S. Supreme Court. Oral arguments were heard a couple of weeks ago, and if the questions coming from the justices are any clue, I think at best it will be a 5-4 decision, and we'll hope for that. On each of these actions, Oregon has not been alone. In each, we work together with other AG offices around the country, one or more of those 21 other Democratic AGs, for the most part, to take on what we see as federal overreach. Another action we can take beyond lawsuits is to issue letters to the president or a member of the federal administration, a federal agency, or members of Congress. And these would be regarding a legal position, regarding an executive order, or a rule change, or such. And you heard about a few of those earlier in the environmental law context. But there have been many that we have signed on to these past 10 months. Just a little sampling. Certainly on the sexual assault, Title IX issue. We've all heard of our friend Betsy DeVos. I sometimes refer to her as Cruella DeVos. She even paid us a visit. We've almost become pen pals. We write to her so often. She is, she's really incredible, and it's just amazing, her portfolio. She is very dangerous because she has such a big portfolio of areas, including sexual assault, including student debt, including schools. It's just frightening. So anyway, this is actually a bipartisan letter through the National Association of Attorneys General, also fondly known as NAG. It really is, it's actually called that. A group of AGs have issued a letter of support to make, this is very serious of course, bump stock devices such as those used by the Las Vegas shooter to turn semi-automatic guns into fully automatic weapons illegal. Now this doesn't go far enough, but this was the most that we could get from a bipartisan group, including Nevada Attorney General Adam Laxalt, whose middle name might as well be the Second Amendment. So we were fortunate to be able to get a bipartisan group to, it's just really too bad that that's what it takes, but sometimes it takes an event like that for someone like him to step up on just this small but very critical area. The DAGA group, DAGA is the Democratic Attorney General Association, also issued a joint letter just a few days ago asserting states' rights and opposing the concealed carry reciprocity bill that's winding its way through Congress. That bill would bring all states down to the lowest common denominator, making the loosest concealed carry laws the law, essentially the law of the land. For many reasons, including our individual states' rights to regulate when it comes to matters of public safety, we oppose that legislation, which seems like an attempt at an end run around the 10th Amendment. So I hope we are doing what good public lawyers do best, looking out for our most vulnerable Oregonians and trying to follow the rule of law. At this moment in history, we're fortunate to have such a thing in our country as the rule of law, and we're even more fortunate that there seem to be judges who value it as much as we do. And yes, what we are doing should be called progressive. As noted earlier in my remarks, today, the work of Oregon's Department of Justice has an added dimension, as we respond each time the president and his surrogates take aim at our liberties and freedoms, the well-being of our people, or the sovereignty of our state. In addition to filing lawsuits and sending letters against the administration, attempting to curtail or diminish the impact of federal policies on states and their individual autonomous self-regulation, we have a few other items in our toolbox. For example, state laws can serve as a critical stopgap against federal overreach and also act as documentation of our state's policy if proof is needed in future litigation. Here are a few examples of Oregon state legislation that we supported or sponsored recently that protects Oregonians in this new and dangerous legal environment. So I'm going to give you 4. First, we already talked a little bit about Betsy. Anyway, one of her efforts was to undo, Betsy DeVos, to undo protections for students such as the borrower defense rule. Now, I know many of you are students, so this is close to your hearts. This rule would have allowed forgiveness of federal student loans taken out by students to attend a school that engaged in misrepresentation or misled students about their education, such as, unfortunately, is often the case in for-profit colleges. So this past session, my office took the lead with an initiative to prevent student debt from becoming the obligation of a lifetime. Senate Bill 253, which is now the law in Oregon, focused on student loan transparency, making sure that colleges and universities send students annually easy-to-understand letters explaining the scope of their federal student loans incurred to date, accompanied by expected monthly payments at the time of repayment. In other states where this has been the law for some time, like Indiana, Nebraska, Wisconsin, students take out smaller loans and they finish college a little bit faster. They save a little money. Maybe it's on coffee or on, dinner. Maybe they cook dinner instead of going out to eat. But whatever it is, they aren't spending as much money, and that results in less debt over time. Another example. As noted, some of the new executive orders are simply thinly veiled attempts to discriminate on the basis of religion. Others create a system that profiles people for ICE enforcement based solely on the language they speak or the color of their skin. So, during this year's legislative session, my top priority was a bill addressing police profiling, House Bill 2355. We had a series of task force meetings, amazing collaboration from law enforcement, the ACLU, and community partners to move this bill forward. Now, I am not suggesting that the purpose of this legislation was to deter ICE, but hopefully it will result in that as a collateral consequence. So as a result of this effort, Oregon law now requires transparency, police stop data collection, and what I mean by that is every time a police officer stops a pedestrian or stops a vehicle, there is a requirement that certain data be collected, and that data relates to the individual, the nature of that person, what their race is, what their age is, what their gender is, and also what that officer does during that stop. Do they ask to search? Do they do a search? Do they just give a warning, etc.? All that information now has to be collected, and it can be collected very quickly, and actually inexpensively too. So very pleased that that passed, and also in addition to that, the training of all law enforcement officers, not only those who are new to the force, because it turns out that there's obviously tons of law enforcement officers who've been on the job for many years. They never got cultural competency training. They never got implicit bias training. They never got the type of training that we now require. And not only do we need to require it, but we need to make it high level. We need to make sure that the curriculum is what is needed in order to ensure that officers understand what the law is and how to comply with it. So at a time when there's increased pressure from federal immigration authorities, we can now say that here in Oregon, profiling based on an officer's perception in 13 prohibited categories is not permitted. And I'm going to tell you what those 13 categories are because I think it's very impressive. A person's age, race, ethnicity, color, national origin, language, gender, gender identity, sexual orientation, political affiliation, religion, homelessness, and disability. Those are all prohibited areas for police profiling. If an officer's perception is based on any one of those alone. Obviously, there's other reasons officers make stop, but if that's the reason, it's not allowed in Oregon. And I must give a shout out here. Our partners in law enforcement should be strongly commended for coming forward with long-needed changes to Oregon's drug sentencing laws as a part of this profiling bill work, making simple drug possession a misdemeanor instead of a felony. No more will we punish low-level addiction in Oregon with a lifelong stigma of a felony conviction. No more will we ask our addicts to combat their addiction while also taking away their opportunities for housing, employment, and social services. My third legislative example springs from the administration's insistence at taking away contraceptive coverage. Although we already had strong laws in Oregon, this past session, I actively supported the passage of the 2017 Reproductive Health Equity Act. This law guarantees Oregonians, including undocumented immigrants, access to the full range of reproductive health services. Our team is taking a deep dive into the new federal rule rolling back contraceptive coverage to determine whether Oregon laws are, in fact, strong enough, or whether there will, despite our strong laws, and we had a strong law even before this one in 2017. In 2007, I think it was, we actually passed a law that pretty much seemed like it would pay for everyone's contraceptive care, but turns out this one was needed to ensure that. Anyway, we're looking at whether our laws are strong enough or whether there will be harm to Oregonians, requiring us to take more aggressive legal action. I said there were four, so fourth, and finally, on the state law front, in addition to our lawsuit regarding DACA, we supported legislation designed to protect our immigrant communities generally. Toward the end of this past session, I was pleased to partner with Representatives Diego Hernandez and Teresa Alonso Leon, who both won awards last night at the event that I attended that I told you about earlier, as well as our governor, in crafting House Bill 3464, which is designed to protect immigrants' private information from enforcement officers in Oregon. So we're stepping it up. We're not satisfied with our state sanctuary law that passed, by the way, in 1987. We wanted to strengthen it. We wanted to make sure that private information about where you go to school, what time you get out of school, when your various appointments are, your home address, your just basic personal information could not be obtained by ICE officers. As a result, my office now has the task of preparing model. We always get work as a result of these laws that pass, but that's okay. That's a good thing. So we now have the task of preparing model policies to help guide all Oregon public bodies in what they have to share and what they can decline to share when ICE asks for documents, information, and access to individuals. We already advise, of course, all Oregon state agencies. That's our job. But there are other public bodies in Oregon, such as schools, hospitals, local governments that have asked for our guidance. So under this new law, we now have the authority to provide it, and we are glad to do so. And we're working on that, and we'll have some guidance probably in the next month or two. So as you can see, I'm a little out of breath here because we're doing a lot. Your Oregon Department of Justice has taken many actions asserting what one could call progressive federalism, including lawsuits challenging the administration's authority to curtail or commandeer states' rights, amicus briefs supporting other states' similar efforts, letters to Congress, members of the cabinet, supporting progressive legislation in Oregon intended to shield our state from extreme federal overreach. Our actions are quite different from those of Republican AGs under President Obama. Their efforts seem like they were to prevent progress, and I think it would be fair to call them regressive federalism. There's one more effort I have personally taken on, and it is no small thing. In fact, I hope you will agree it is one of the most important progressive actions a leader can take in these times. In response to the horrible Max train murders last May, my office convened a symposium this past July, so 2 months later, at the Muslim Education Trust, entitled Zero Tolerance on Hate. This symposium brought together faith leaders from most religious groups, judges, leaders in the immigrant communities, prosecutors, law enforcement, elected officials, and even the sister of Taliesin Mirdin Namkaimeche. And I don't know if I said his name right, but that amazing hero who lost his life in the process. Those who attended the symposium committed to taking a thoughtful, principled stand against hatred and intolerance while coming together as a community and learning from each other. It is exactly this sort of gathering that keeps all of us here in Oregon safe and strong. These are unprecedented times, and we must make it clear that hatred, bias-motivated crimes, and other acts intended to invoke fear and terror will not be tolerated in Oregon. As a judge for many years and your attorney general for the past 5, I am a firm believer that it is justice and the rule of law that we must turn to as a shield against oppression and a banner for fairness and equality in the face of hatred and hostility. So I know you're all busy, but here's my challenge to all of you. It's likely that you're not just here for the CLE credits. In fact, I noticed you don't get any credits for listening to me. Maybe that's because I'm elected, but anyway, I'm glad you're here despite that. You're here because you're concerned and because you care about the future of our state and the well-being of our nation. You've heard about the work we're doing at the Oregon Department of Justice, and many of you are active and involved in the legal community and likely beyond. And you consider yourself a progressive. So whatever role you can play, however expansive or finite, in whatever arena you are most comfortable, whether it's in providing legal services, guiding law students, yay, engaging in electoral politics, social service, charitable giving, or being the individual support for a person in need. It doesn't matter what you do. Just do what you can, because we need all hands on deck in these challenging times. In the words of the late Senator Robert F. Kennedy, few will have the greatness to bend history itself, but each of us can work to change a small portion of events. And in the total of all of those acts will be written the history of this generation. we now have a new generation to protect. I have 2 little grandchildren, so I'm reminded of that every day. So thank you in particular to the wonderful law students who put this program together and for inviting me. It's an honor to be in the presence of this very distinguished group, and I wish you a wonderful afternoon. Thank you. I think I have a few minutes for questions if you have any, but you also might just want to eat your lunch. So, questions, comments? You want copies of any articles or letters or anything? Yes.
I think it's great that Oregon has had this law on the books for so long that prohibits the expenditure of funds by state and local law enforcement for immigration purposes. But has there been any thought given to the enforcement of that by legislation giving either a private right of action or giving the Attorney General power to ensure that law enforcement agencies that violate that are called to task?
Well, that's a good question. I think we probably could enforce that law, actually. I don't know whether or not we have been asked to. I don't know about the private right of action, though. But I think in terms of the Attorney General's role, we could certainly enforce that if we believed it was being violated. And one of the reasons that we moved, to this next level that I was just talking about with the additional law is that we wanted to have more enforcement and we wanted to have more clarity about what was against the law. So that was really the reason for going to this next step. And we had, it was right around the time that ICE was hitting Woodburn, and people, the downtown was literally empty because people were so afraid. Kids were afraid to go to school, still are. So we are definitely keeping our eyes and ears on it. And thankfully, we have a wonderful advocacy community. We have people like Catherine in the back here, who's organized a surveillance program out in, is that the right word to use, Catherine? Out in Washington County. Observers, yeah, I don't want to say she's surveilling anybody, but basically an observers program out in Washington County to keep eyes on what ICE is up to, because they're saying they're in compliance with the law, but we're pretty sure they're not. So between, I think, a really good partnership with the advocacy community and certainly some opportunities for the state to enforce these laws, we'll do our best. If you want to propose additional private right of action, we'll be happy to talk with you about it. But I think that I've seen that individuals are suing and that the ACLU has been taking on some of their cases. So I'm fairly certain that there already are ways to bring private actions. Yeah, in the back. Yeah, well, I would say that to a degree we learned from them. I mean, there's no question, but that we're to a degree taking a page from that successful playbook. One of the things that they did that I think is pretty smart is they did a little judge shopping. And I guess I'm being videotaped here, but hey, look, if there's a state or a court that seems to be more, kind of maybe interested in certain issues, maybe more inclined based on prior rulings to go a certain direction, I don't think that we would shy away from that. So that's something that we're certainly benefiting from the experience with the Texas court, for example, by the Raga lawyers. Sure. Why not, right? It's an open book. It's all public records. And let me say this. There are a number of bipartisan, in addition to, I mentioned the gun letter, but we actually work together with our Republican counterparts quite a bit. Right now, there's 2 areas that I would mention. One is the consumer credit reporting, the Equifax breach. I mean, that's something all of us really care about. There's over 40 attorneys general working together on that multi-state. We do a lot of work together on consumer multi-states. The other one is the opioid epidemic. That is like, if anything, the Republican AGs have taken the lead in certain respects, although Oregon's quite involved and quite out there. So, for the most, what I was talking about today, of course, for the most part, are the Trump administration rollbacks and the pushing back, but there's quite a bit that we do together. We still have this, in fact, NAG, the organization I mentioned, is meeting here in Portland next summer for the summer meeting. So all the AGs in the country are going to be right here in this town. Yeah, you guys should come over. I'll invite you. I'll find a way. If you're interested in coming, let me know, okay? We'll get you to one of our receptions or something. I'll introduce you to some of the big names. Okay, yeah, hi.
Hi, we're from Nevada, so we have our
Oh.
directors in Marshall.
Yes, well, you can tell them what I said.
I just wonder, as a pursuing attorney general position, how do you pick what battles to tackle? Is it likelihood of success? Is it listening to constituents? What's the process to choose what to focus on?
Sure, because there's so much, right? And we do have to pick and choose. And like I said, out of the 52 environmental actions, we've only actually formally weighed in on 20 of them, which seems like quite a lot to me. It seems like every day my chief of my natural resources section is sending me a letter to sign on to. Signing on to a letter is pretty easy to do, right? It's fairly inexpensive. It's not something that's going to take a lot of resources. Joining a lawsuit where it's being brought by another attorney general in another state, and there's a number of us joining together, might seem like it's not a big deal, but it actually is. In all of these cases, we've had to spend hours. In fact, I think there was a report the other day that of the 4 major ones, we've so far spent, if you will, $100,000, which honestly is pretty cheap when you think about what we're doing and how much effort it takes to handle these types of cases. But so we've been very careful about which cases we join, and what we look at is what's the harm to Oregonians. I'm not going to join the emoluments case, okay, because we don't have a Trump hotel in Oregon. Now, some would say that there are other ways in which maybe there's even some standing in our little state, but that's just not one I'm playing on, okay, even though I've been asked to. And frankly, within the area of the contraceptive case, you might have noticed that 3 or 4 states immediately sued. We didn't. Why? Because of what I told you today. We are looking very carefully. We're doing that deep dive, but we have better laws, better state laws in Oregon in this area. So luckily, fortunately, hopefully, we may not have to sue. But if it looks like we do have kind of a window maybe where, because the new law doesn't go into effect until next year, and so there's various things we have to look at, guarantee you we'll be there. Same with Planned Parenthood. Planned Parenthood gets defunded, we'll be there. But at the moment, we're still okay on that one. So we're just, looking out for, it's a little bit like a game of whack-a-mole. But it is, but it isn't, because there's clearly this intention out there, this attempt to roll back just about every advance of the Obama era. So mostly it comes down to what's the harm, how many people are harmed. Somebody asked me the other day, who is a very wonderful young man with a disability, well, why should it matter how many people are affected? What if just I'm affected? And so I can't say it's how many, because sometimes it is the issue and not the person, not the numbers. But it does have to do with the overall impact on and harm and damage to Oregonians and to our land. Any other questions? Well, thank you very much for having me. Enjoy the rest of your day.